5, 4, 3, 2, 1. Start. This court has carefully perused the facts presented before it in the matter arising out of the complaint filed by the petitioner alleging a violation of procedural safeguards in the acquisition and subsequent possession of agricultural land for purposes stated to be in the interest of public utility. The respondent authority, on the other hand, has submitted that all steps were taken within the framework of the prevailing law and that due care was observed at each stage of the acquisition proceedings. It is submitted that public notices were displayed and affected parties were given ample chance to raise objections before the competent authority. The learned counsel for the respondent further submits that the land in question was required for an urgent and unavoidable public project, and any delay would have adversely affected not only the progress of the project but also the larger interest of the community at large. The court must, therefore, consider whether the procedure followed was, in substance, in conformity with the law and whether the petitioner has been prejudiced in any demonstrable manner. This court is of the opinion that in matters involving acquisition of land, especially where the livelihood of individuals is at stake, the procedures laid down by the law are not mere formalities but are intended to ensure a fair hearing and transparency. The opportunity to file objections, and the duty of the acquiring body to consider the same are central to the process. The material placed before the court suggests that there was indeed an initial notification, but the record does not clearly establish whether the same was served upon the petitioner in a manner that would allow him to exercise his right to be heard. The record is also silent on whether a personal hearing was ever granted or reasons recorded in writing for dispensing with such a hearing, if that was the case. It is not denied by the respondent that physical possession was taken of the land even before the lapse of the minimum period prescribed for filing objections. The justification advanced is that the urgency clause was invoked and the matter fell within the exceptional circumstances warranting immediate possession. However, the invocation of urgency cannot be an arbitrary act. It must be backed by sufficient material showing that any delay, even of a few days, would have rendered the objective of the project meaningless. The documents placed before the court do not inspire confidence that the urgency was of such a nature. The urgency clause, being an exception to the general rule, must be construed strictly. The court cannot remain a mute spectator where the rights of individuals are adversely affected without due process of law. Furthermore, this court is not inclined to accept the argument that the petitioner's claim is belated. It is evident from the material available on record that the petitioner approached the authorities through multiple representations within a reasonable period after he became aware of the action taken. The fact that no effective reply was furnished to the petitioner further strengthens the impression that his concerns were not addressed in a meaningful manner. It is not in dispute that the land in question formed the sole source of livelihood for the petitioner's family and the loss of possession has resulted in severe hardship. Another aspect that deserves attention is the issue of compensation. it has been urged by the petitioner that the compensation awarded was neither adequate nor in accordance with the fair market value prevailing at the relevant time. The respondent has submitted that the award was passed as per the valuation conducted by the competent authority and that the petitioner was at liberty to challenge the same through an appropriate forum. However, it is a settled principle of law that compensation must be just, fair, and reasonable, taking into account not only the market value but also other factors such as the potential of the land, the inconvenience caused to the family, and the time taken for rehabilitation. The court cannot shut its eyes to the growing tendency of mechanical invocation of urgency and inadequate attention to procedural safeguards, particularly in rural and economically weaker areas. It is the duty of every authority, while exercising the power of acquisition, to be conscious of the fact that land is not merely a piece of property for the poor but a means of survival. In view of the above observations, and after a careful consideration of all submissions made and the documents presented, this court is of the opinion that the petitioner has succeeded in making out a case for interference. The acquisition cannot be sustained on the grounds presented by the respondent. The possession taken without affording a proper opportunity to the petitioner and without establishing the urgency in concrete terms is in violation of the principle of natural justice and statutory requirements. Hence, the impugned acquisition and related actions taken by the respondent are liable to be quashed. The court, therefore, directs the respondent to restore possession of the land to the petitioner within a reasonable time, subject to verification and compliance with procedural formalities. In case the land has been altered in a manner making restoration impractical, the petitioner shall be entitled to enhanced compensation, which shall be determined afresh by the competent authority within a stipulated period. Until such determination is made, the petitioner shall be paid an interim relief equivalent to the last assessed market value plus reasonable interest, as an acknowledgement of the hardship faced. The court also deems it appropriate to observe that public authorities must be sensitized about the importance of adhering to the rule of law while exercising extraordinary powers. Arbitrary use of such powers not only causes hardship but also affects the credibility of public institutions. It is hoped that appropriate instructions shall be issued to the concerned departments to avoid recurrence of such issues and to ensure that the rights of citizens are not compromised in the name of public interest. Stop.